Elder Abuse Awareness Day. Again, World Elder Abuse Awareness Day. June 15th is recognized as World Elder Abuse Awareness Day, highlighting the urgent need to protect older adults from abuse, neglect, and exploitation. Why do we observe World Elder Abuse Awareness Day? Because approximately 1 in 6 older adults experience abuse, most often by someone they trust, such as family members or caregivers. Elder abuse threatens health, safety, dignity, and independence. So our role today is to deepen understanding of the judicial process in elder abuse cases, to explore how courts and community organizations can work together to empower and protect our elders, to encourage bold action and open conversations that reduce risks and promote safety. Yes. Attorney Greg Palmares, our supervising attorney of the project, will introduce Honorable Michelle Tong. Thank you.
Thank you, Junko. So I have the privilege to introduce our speaker for today. So we have Honorable Michelle Tong. So Honorable Tong was elected to the San Francisco Superior Court in March 2020 and began her position in January 2021. Currently, she is assigned to civil harassment, default judgments, and traffic trials. Judge Tong was previously assigned to small claims in Unified Family Court, where she presided over a variety of family law areas, such as child custody, visitation, domestic violence, dissolution, spousal support, and property division. Prior to her judicial career, Judge Tong was with the San Francisco Public Defender's Office. She tried over 50 jury trials to verdict, ranging from misdemeanors to serious and violent life cases. After law school, Judge Tong also spent 2 years assisting self-represented tenants facing eviction at the Eviction Defense Collaborative. Judge Tong was born in Toronto, Canada, to immigrants from Hong Kong and resides in San Francisco. She received her bachelor's degree from the University of California, Santa Cruz, and a law degree from the UOP McGeorge School of Law in 2001. So without further ado, we would like to transfer the stage to Judge Michelle Tong.
All right. Good afternoon, everyone. Can you hear me all right? All right, good. Thumbs up. If you can't hear me, just do a little emoji, or I think there's some instructions in the chat box as to how to handle the technical difficulties. Well, first of all, I just would like to thank API Legal Outreach. I call them APILO, and Greg Palmares for inviting me to be a guest speaker on this in honor of this momentous occasion. World Elder Abuse Day apparently was on Sunday, and I don't think anyone would like to spend their Sunday listening to me talk. So it's deferred by 2 days, but here we are, and I'm just really excited to talk about this process. So I think, Mr. Palmares, if you could just move to the next slide. You'll see the slides before you, and I'll read generally from them. Some people like to read on their own, and some people like to listen, and so I'll sort of do a little bit of both. I know that they don't, some people don't want to hear this echoing voice, so I'll just skim along here. But an overview is that in California, elder abuse cases can involve physical, emotional, or financial harm, and they may occur in private homes, care facilities, or even online. And I would extend that to just even daily interactions. There's definitely various prejudices and stereotypes and judgments that we have with varying members of our society, right? Whether they're young people, teenagers, elders. And I think we've all seen that. And even in our own family, we may see disparate treatment or different treatment as it relates to elders. But the focus today is to talk about the judicial process, and it's designed to protect elders and dependent adults and provide remedies and coordinate with community agencies. So elder abuse can be reported by a variety of ways, by the victim, by families, family members, mandated reporters such as social workers or APS, which stands for Adult Protective Services, or concerned community members. APS investigates reports of abuse, neglect, or exploitation, providing case management and coordinating with law enforcement when necessary. In care facilities, the long-term care ombudsman program may investigate complaints and advocate for residents of residential care facilities for the elderly. Various ways in which elder abuse cases or people that are considered elders may enter the court system is in a variety of ways. You have criminal actions where elders can be a witness, a victim, a defendant, or accused. They could be a support person, meaning they're not excluded from the legal process or legal space just by virtue of their fact that they are an elder. They may enter the system by way of civil actions for damages or restitution, or meaning as a plaintiff or as a defendant. The elders may request for restraining orders, which is where I'm primarily focused and assigned to, which can include elder or dependent abuse restraining orders. And elders may also be included as protected parties. So for example, a non-elder family member may seek a restraining order and include the elder family member because, as not surprising to folks, you have multi-generational family structures that live in one home. And so if there's a restraining order request by a family member, they may want to include extended family members such as the elder, and that could be allowed. And finally, you have probate and conservatorship proceedings if the elder is incapacitated, or you're dealing with, I would even extend this to decedents, elder decedents, meaning elders who are then decedents and they have an estate issue, and you have surviving members of the elder's estate, that there might be some issues, legal issues that need to be resolved by the courts. So I will be talking more about this. It's just an overview, but when it comes to protective orders, elder and dependent abuse restraining orders can be requested by the elder themselves, as long as they are 65 and older, their representative, or APS, to stop abuse or neglect. The benefit of elder abuse restraining orders compared to other types of restraining orders, such as civil harassment restraining orders between roommates, strangers, neighbors, is that there's the filing fees are waived for an elder abuse restraining order, and temporary orders may be granted quickly, meaning on the same day. I think what I'll do is let me go to this next part. That sorry, go back, Greg. All right, other restraining orders may apply, such as domestic violence or civil harassment orders, depending on the relationship between the parties. And I'll talk more about that, but it can intersect. Just because you're an elder, you're not confined to only using an elder abuse restraining order. There are other types of restraining orders that can capture an elder. You should not be rejected. So long as the relationship is met and the category is met, an elder can use any tool so long as it meets the categories. All right, next slide. When court hearings are conducted, for civil harassment restraining orders and protective orders, they are scheduled promptly and both parties will have an opportunity to present evidence. The court may appoint a guardian ad litem or conservator to represent the elder if necessary. And there are elder accommodations, which I'll discuss in more detail later, such as assisted listening devices, support counselors, to ensure the older adult understands the process and has access to the legal process. There are remedies and enforcement that are associated with protective orders, some and other civil lawsuits related to elders. Remedies may include compensatory and punitive damages, attorney's fees, and orders to freeze assets to prevent further loss, criminal convictions, which can lead to restitution, fines, or incarceration against the abuser or the person that's affecting the elder. And courts do work in partnership with community agencies to provide ongoing support, legal advice, and referrals to services. So now I will talk about the various types of cases in San Francisco Superior Court that touch upon and may affect elders. As an overview, elder abuse cases in San Francisco Superior Court span a range of legal areas, reflecting the complex ways abuse can occur and multiple forms of protection and intervention the court can provide. Cases may range from civil, criminal, probate matters, and may address physical, emotional, or financial harm, as well as neglect and abandonment. So the first type of area of cases that affect elders are elder abuse restraining orders, which I will devote most of the time in terms of what type of legal cases affect seniors, just by virtue of the fact that this is my primary assignment. And I'll note, so these are just some highlights of elder abuse restraining orders. As I noted earlier, if a person is an elder, at least 65 and older, that elder may request a elder abuse restraining order. And the same form, and it's called a form, and we'll see more of it in a moment, but it's called, I'm going to actually hold it up myself. We'll see it in a moment, but it's these judicial council forms. Can you see it? No, let me see. I have my screen blanked out. Maybe Greg, you can help me. Oh, here we go. There you go. It says that you probably can't see it from here, but on the top left, it says EA 100. These forms are easily accessible and can be found by a simple Google search. If you just Google California elder abuse form, I'm certain it will pop up very quickly. And I'll give some more links or addresses as to where you can find this information. But this, oh, thank you, Greg. Greg has it right up here. This form can seem rather intimidating. I can tell you that. There's a lot of questions. There's a lot of italics. There's a lot of lines. And so it does require a careful reading of the form. But I'll say this, despite the intimidating look of the form, any errors, so to speak, whether it be factual errors or even writing in the wrong spot, or maybe you find yourself writing in one portion of the form and realizing it should have been in another portion, none of these errors are fatal to your request for, or a person's request for a restraining order. This isn't like a test where, you know, if you fill it in wrong, then you'll fail. It's the beauty of the form. It's just really it's guidance to help you answer the relevant questions that are in line with the law, and it allows the judge, the bench officer, whoever it is, to review what it is the allegations are and what it is that the elder is asking for, what kind of protection they're asking for. So really, it's your own words. So the questions and the forms is there to guide you, but like I stated, you're not beholden to those particular portions. You can write it wherever you want. And, you know, a lot of people, and so feel free to, you know, I mean, I've had people, I'm not encouraging this, but I've had people write along the trims, the margins. So, anyway, I digress, but, Mr. Gray, could you go back to the? But I just want to summarize that the elder abuse restraining order form, which is this one, and I'll talk more about it later. As long as you're 65 and older, and then you fill out the form, it asks for what's the abuse and who needs protection. You fill that, and you, that's really primarily the triggering, qualification is that you're at least 65. If you're not 65 or older, or you do not have you're not a dependent adult, you won't be using this form anyway. An elder abuse restraining order can be requested by an individual, a conservator, someone with the power of attorney, APS, or an advocacy organization. I'll say, for example, I think I have a restraining order coming up on behalf of an elder, and it's evident in the restraining order request that it is a family member. I think it's a child asking, an adult child asking for a restraining order on behalf of their parent against the step parent. And that was clear in the papers. And so my question in my mind would be, how does this, even though there is a family relationship, this petitioner, the one that's asking this, the child, needs to have some legal authority and or permission from the senior to, or the elder to make this request. And I'll say why that's important. So what would be required either at the time, not necessarily at the time of the filing of the request for the restraining order, but at a minimum at the hearing, they would need to present the court with the legal authority that allows the child or the non-elder to make this ask on behalf of the elder. You have advocacy organizations such as Apilo, Greg Palomares, who's the attorney of record at times for the elder. I see Judy Hitchcock here with who's counsel with legal assistance for the elderly. You'll have attorneys that work with or for advocacy organizations that appear on behalf of the senior. So there's a variety of ways in which an elder may ask for a restraining order, even if it's not themselves. I'll note that temporary restraining orders can be issued quickly, and permanent orders may last up to 3 years and be renewed. So I know that there's a range of participants or viewers here today that may be very familiar with the process, and some that may not be. I'm not clear of the range, but I think it's worth indicating that there is a two-step process. I'll say two. Once a request is made for a restraining order, the nuts and bolts of it is, at least in San Francisco, and I think that's something similar with other courts throughout California, is the person goes to the filing window and fills out all those papers and makes all the relevant copies and files it with the filing clerk. All right. And that would be, they go to court on one day. For example, let's say today's Tuesday, they drop off the papers today on Tuesday, and they file the request for the restraining order. And that part is called the temporary restraining order. And you'll hear people call it a TRO. So the first step of the process is filing the TRO. And when the beauty or the purpose of the TRO is that the abuse or the allegation, the bad acting, the behavior that's leading to the filing of the restraining order, the abuse, is so urgent that the elder needs protection, and this happens with all the other restraining orders also, is that there needs to be a quick response to that request for a restraining order and for that protection. So at least in San Francisco, you drop off the papers the day before or on day one, and you're instructed to return the following day after 2:30 to pick up the TRO. And at that point, you'll learn whether your TRO request has been granted, denied, or some combination in between. Thank you. And Mr. Greg is showing the what the TRO, also known as the temporary restraining order, looks like. And what this stage means, though, is the other person that's the elder is asking for a restraining order against does not even know that a restraining order is being sought. All right. I'll repeat that. This other person, the respondent, has no idea generally, or maybe they do, but in terms of actually the filing, and that's what's called it's called an ex parte request, which means a one-sided request, or but the respondent doesn't know that the elder has gone down to court to make this request, and then the judge actually will review the petition for the restraining order and make a decision on the TRO based only on what the elder is alleging. All right, and that's completely permissible and allowed. And what will happen then, though, is within 21 days, that's the statutory timeline, or I'll just use it as 21 days, there will be a hearing set automatically. So when the elder goes on day 2 to pick up the TRO, which you see on the screen, there's a date. Can you scroll down? Greg? Yep, there you go. This is still the first page. On page 1 of the TRO, it will say, you see expiration date, and in that slot will be the hearing date. So when the elder goes on day 2 to pick up the TRO, there will be a date there, roughly around 21 days, for the actual hearing. And at that point on the hearing, the other side, if they're properly served, would have an opportunity to respond to the allegations, if they so choose, to the petitioner's allegations. So that's what I call to be step 2. Step 2 is the hearing. That's the actual hearing in front of the judge where you're presenting evidence, arguments, things of that nature. So part 1 is the TRO, and then part 2 is the actual hearing. All right, let's go back to the slide. So the reason I digress there is because on bullet point 3, it says temporary restraining orders can be issued quickly. I wanted to just address what that meant. So the TRO can be issued quickly. It also can be denied, but even if it's denied, there will still be a hearing. All right, so whether the TRO is granted or denied, there will still be a hearing, because at the hearing, and I know that I've experienced this, even if I've denied a TRO, the evidence will present differently at the hearing, and then I'll change my mind based on the evidence, and I will in fact grant the restraining order. And I'll note that after the hearing, permanent orders may last up to 3 years and can also be renewed. The restraints of the restraining order may include things like do not contact the elder at all. So you have to stay away from them. There's a move out provision, and you have to relinquish firearms, and there can be a variety of other personal conduct restrictions. It can include family members, as I stated, pets. There's a whole host of different things that can be requested. There's no shortage of it. As I said, there's lines for people to include what that is. I mean, I have people ask, please do not talk about the elder to, at family functions, things like that. So there's a wide range of things. So what, Mr. Greg, why don't we do, I would like to say, can you break out to that second screen to the full form, please?
You want to see the form, Judge Tong?
Yes,
Yeah.
yes. All right. And can you make it a full screen? All right. So as I stated, I'm not going to go through the entire line by line because you all fall asleep after that. But I just want to share with you what it looks like and what it means. So this is what's called a judicial council form. The Judicial Council of California creates a variety of forms. And this is what the actual request looks like. And you'll see that it's 9 pages on the bottom right. And so, as I stated, it's pretty lengthy, and it is 9 pages of questions. But I'll just run it through. But basically, on the top, you say who the elder is. But primarily, if you see the age, you'll mark. Can you go there, Greg? If you see the age, that's the number. That's where you place the age. So when I'm reviewing elder abuse restraining orders, there are certain, like I stated earlier, there's certain elements that need to be met and shown. So the first thing I'm looking at is, what's the age of this person? Is this the proper form? And then I go through the rest of it. Who is the one that's asking for protection? And I'm just flagging in my mind and taking notes. If you see on section 3, who is asking for the restraining order, and it will give boxes. Are you the conservator, the estate, the person? And you just answer the question accordingly. As you go down, there's just information about who's the contact person representing the elder. Let's turn the page. Do you have other pages? Okay, great. And so here just talks more about the description of the person, and see if you see here additional protected parties. So you're really just answering the questions. Go to page 3. This is where the meat and potatoes is. All right. And this is where you're getting to the heart of why you need a restraining order. And it just says, describe the abuse. In this language, abuse may mean either of these things. That's really an attempt to mirror the statutory language that allows for a elder abuse restraining order. So it says, and I'll read it in case you cannot see it. Abuse can mean physical abuse, neglect, financial abuse, abandonment, isolation, abduction, or other treatment with resulting physical harm or pain or mental suffering, or, and this is important, the withholding of caretaker of goods or services that are necessary to avoid physical harm or mental suffering. Not a surprise to anyone here, or shouldn't be, I would say, when you have a vulnerable population like elders that depend on, and you have very spry elders, but you have some elders that really need physical assistance to take care of their own health needs, food services, and even sanitation. They're nonverbal. And so there are situations, they're very tragic, quite frankly, where you see situations where the caretaker is not providing the bare essentials, such as feeding them, cleansing and cleaning for the senior, whether it be their family member or whether they're hired to do so. And those are the extreme cases. Fortunately, I don't see many of them, but I have seen some of them. But I just want to say that just the withholding of those types of goods and services can rise to the level of elder abuse. And then this just goes on to ask more questions. When did it happen? Who was there? You have situations, if you see on section 8.4, it says, was it solely financial abuse? Sometimes you have situations, sorry, is it one before? Greg. Sometimes you have situations where actually the senior is well taken care of. That could be part of the manipulation, right? The senior is well taken care of or well cared for because the caretaker, whether it be family member or agency or whatnot, or hired person, ingratiates that trust so that they can take advantage of the finances because they have that proximity to the elder. So I have seen situations where it's only financial abuse, it's not physical abuse. And maybe some other family member learned of this or has concerns of this. So this restraining order accounts for that type of abuse as well. So I'm not going to go into the rest of it, but just, like I've said this numerous times, just follow the prompts on the form and answer the questions. And if it just gets too much, there's oftentimes you can just provide an attachment to the declaration, photos, exhibits, pictures, photographs, or photocopies of emails, text message exchanges. All those things are helpful to the bench officer when they're reviewing not only a TRO, but in preparation for the hearing. I want to move to, let's move to page 5 of the order of the request, which is important. So here on page 5, after you've explained on the prior pages what the bad behavior is or what the abusive behavior is, then you go to this page and you need to tell the judge what it is that you want. So and you just look at the boxes and you just mark the ones that you want. So the section 11 is about conduct. Conduct such as you do not want the person to physically abuse the elder, financially abuse them, intimidate them, molest them, attack them, strike them, and so forth. And then the next section is the elder doesn't want the defendant or the respondent to contact them at all. And you can mark that. And then there could be other things. For example, I've had people say, whether it's granted or not, but you can make the ask, don't talk about me at family gatherings or something like that. But the point is, this is the page where you make the requests in your restraining order as to what you want the judge to do in this restraining order petition. Now, this is what's interesting that I find about elder abuse restraining orders. If you look at the section B, 11B, it says, do not contact the person directly or indirectly in any way, including but not limited to in person, in telephone, in writing, et cetera, et cetera. What happens with elder abuse restraining orders, in particular when there's some sort of pre-existing relationship, like a family relationship, it can get complex because what the elder is asking for is they don't want to be abused financially and exploited and taken advantage of, but they don't have, or their voice is not being honored. And so that's what they're asking is they want the abuse to stop, but they don't necessarily want to sever contact with their abuser because it could be a family member and that can be challenging. So sometimes I'll have petitioners not mark this box to say that they don't want to be contacted. They actually do want to be contacted. They just don't want to be abused. All right. And so I just wanted to say that that's whether you're doing this on behalf of an elder or you are asking on your own, you just want to think about what you want and walk that through if that request is granted. Because some people will ask for the no contact for part of it and will mark this, and then immediately after, because they have feelings, they love their abuser or whatnot because it's a family member, they call their family member up and say, come over for dinner, come take me to the store, whatever the case may be. And so it can get confusing. So I think just the takeaway is just to be thoughtful about what it is you're asking for. And if you're going to ask for no contact, you have to stick with that at least until the hearing to figure out if that's what you want to maintain, if that makes sense. And sometimes it's better for the situation. Sometimes you just have to cut off all ties. All right, and then the part 12 is the other really important part of the ask and the request is the distance stay away order. You want to ask the court to order the abuser to stay X amount of yards. Now the outer limits is 150 yards, 100 yards, depending on the situation, depending on the bench officer. In criminal courts, protective orders, at least I've seen, tend to be 150 yards. Sometimes they're 100 yards. there's a lot of exceptions to that. For me, it just depends on the facts. I think it's not, the point is, it's not a cookie cutter situation. It's not always 100 yards. It's not always 150. It's not always 50. It just depends. I look at things like, you know, what are the chances that the two people will run into each other in other parts of San Francisco or at a community center, or is it just in the home, or what are the circumstances? Because I need to balance the protection of the petitioner as well as the overreaching and overbroad restraints against the respondent. And so this is the page that you ask for. You make your request as to what it is that you want as part of this restraining order. So I wanted to highlight this part. The other part, go to page 6. This is the next important part. What comes along with elder abuse restraining orders and domestic violence restraining orders, only these types, 2 types, is section 13, which is important. It's called the move out order. If the elder and the respondent live in the same household with elder abuse restraining orders, even at the TRO phase, may ask the respondent to move out and not return. So remember when I said earlier that sometimes the respondent may not even know that the petitioner, the elder petitioner, is actually in court filing a request. They may also not know that they're asking for a move out order. Next thing you know, the judge grants it, which they can, and the sheriff go to the house and they're knocking on the door saying, okay, respondent, the judge ordered you to move, and they had no knowledge of it, but that can be allowed. And so, and the reason why is because the abuse upon this vulnerable party, the elder, is urgent, and the danger needs to be ceased immediately. And so in elder abuse restraining orders and domestic violence restraining orders, that is the one additional ask that is allowed in these types of protective orders that is not available in the other types of restraining orders. So I wanted to highlight that portion of the petition. And the opposite can be true. You have people, like in every situation, that abuse this process and know that this is a remedy and may file it knowing that they can have the responding person immediately excavated from the home. All right, so it can be a good thing and also a bad thing. I think I can skip the rest of the part, but I just wanted to highlight those portions. I'll also note that along with just the request, there are other things that need to be filled out. I'm not going to go into every nook and cranny since this is not like a clinic presentation, but just be aware there's also the form that was shown earlier, which is the actual order, which will show the date of the court date. And then there will be another form, it's called a EA 109, which shows this is the notice of the hearing. And then there's another form that has to be filled out. It's the law enforcement form. So there's 4 forms. That's what I was saying. The main form in and of itself is 9 pages, but there's 3 additional forms that are companion with the main form that all need to be filed when you're making the request for the restraining order. If you do not have all 4 of those filled out, I suspect you'll be turned away and you'll be on the side of the filing window, you know, furiously trying to figure out how to fill out the rest of the forms. All right. I'm just thinking if I wanted to talk about the hearing. Let me talk about the hearing. When you actually have the hearing for the restraining order, assuming that after you've received the temporary restraining order, whether it's granted or not, the defendant respondent must be served. I'm not going to go into all the service rules, but with a elder, just a moment, let me see something here. With an elder abuse restraining order, whether the restraining order is granted or not, the TRO is granted or not, the elder is entitled to the sheriff serving the restraining order upon the respondent for free. All right, you could have someone else do it for the senior, but if you exercise or employ the use of law enforcement, it is done for free. That's another benefit of having an elder abuse restraining order. So at the hearing, sometimes the respondent shows up, sometimes they do not. If the respondent does not show up, then it's considered a default restraining order and the petitioner, the elder, is still there. It will be a one-sided hearing. And if the respondent does show up, then it will be a contested hearing. We call it a contested hearing. And you hear from the petitioner, then you hear from the respondent, and then back to the petitioner. And at the hearing, as well as the temporary restraining order, the standard of proof is preponderance of the evidence. So that's the standard of proof. It's lower than a regular restraining order, which is clear and convincing evidence. And the highest standard of proof in the legal system is beyond a reasonable doubt. So it's for elder abuse restraining order, it's preponderance of the evidence, which means in layman's terms, is it more likely than not the that the abuse occurred? And I'll note that you could show past acts of abuse, but there's not necessarily a need under the law to show that future acts will continue or repeat itself. So at the hearing, people like to come forward with their support person or their lawyer. They can come on their own and have evidence such as videos, documents, photographs. I see a whole host of different types of evidence presented in support of their request. All right, so I know I'm supposed to answer, I was going to wait to answer questions at the end, but I think sometimes it's helpful to talk about, depending on the question. I'll say that. So I did see a question, and this is the question. Does this form, which is the elder abuse form, does it work for disabled adults experiencing abuse to receive a restraining order? And yes, it does. In fact, I just had a case like that today where it was evident, and I looked at the age of the petitioner. The person was definitely not over 65. I think the person was maybe in their mid-30s or whatnot. And I asked, I confirmed, first of all, that the person was not an elder based on the age as indicated on the form, and the petitioner confirmed that they were not an elder, but indicated that they fell into the second category, which was a disabled adult. So, all right. So I'm going to move to the next type of cases, in which I'm more going to just touch on as overview as to the other types of cases that come into the San Francisco Superior Court that affect elders. So we have probate, conservatorship / related abuse cases where the probate court, and there's two courts here, they hear elder abuse petitions related to existing or pending conservatorships. And conservators and or their representatives may seek court intervention if there's abuse or exploitation is suspected during a conservatorship. And I believe, so this is not my area, I would say. I'm sure Mr. Palomares and Ms. Hitchcock have much more knowledge about this area, but I believe that from what I understand, there can be people who bring a complaint or a case asking for the elder to be appointed a conservator, even if the elder wants one or I mean, doesn't want one. That could happen. So that's where you see some protections occurring. All right, next. So this is, I've already talked about civil harassment. Well, I've talked about specifically elder abuse restraining orders, but this slide addresses, as I said earlier, other types of restraining orders where it may overlap with the person being an elder. So for example, and it's up to the petitioner. You may have a petitioner who's an elder that brings just a regular civil harassment restraining order against a person. It could be because they don't know, or maybe they choose to bring a regular restraining order. It's a different standard. It's harder to receive a restraining order when it's just a regular civil harassment restraining order. But it can happen. Or it could be that the other side, the respondent, is an elder. And if that's the case, it would just be a regular civil harassment restraining order. Or I've seen situations where the elder petitioner and respondent are in a relationship, either past or present. They were married, or they're intimate relationship, and technically they could actually go get a domestic violence restraining order. But instead they do an elder abuse restraining order. You could do one or the other. And the reason why one might want to do a domestic violence restraining order rather than an elder abuse restraining order, even though the standard is the same, is because there could be other related consequences. For example, if the parties are married, there could be spousal support that's involved, child custody issues involved, things related that overlap with family related issues that the elder couple may want to file a domestic violence restraining order rather than an elder abuse restraining order. And that's the second one I just noted. I'll let you know that in my court, I don't hear the domestic violence restraining orders. They are heard and set aside in the domestic violence restraining order court, which is part of Unified Family Court. All right. Next. There's also criminal cases, which I am not seeing, but over at 850 Bryant Street in San Francisco, at least, there's an actual penal code, and there's some others, but the main one that you'll see often is violation of Penal Code Section 368, and the language is there, which says that a person who knows or reasonably should know that the person is an elder or dependent adult who, under the circumstances or conditions likely to produce great bodily injury or harm, willfully causes or permits an elder or dependent adult to suffer or inflicts thereon unjustifiable physical pain or mental suffering. That abuser could promptly be arrested and charged with a crime. It could be a misdemeanor. It could be a felony, either of which are crimes. And any violation of this penal code could result in not just criminal protective orders, which are different than the civil ones, restitution, fines, or punishment. Incarceration. And it could be even state prison. So, and this is just the bare bones of the crime. There's a lot of things that can be attached. For example, if there is companion financial abuse, there could be financial abuse charges. If there's physical injuries and they're severe, then there can be additional great bodily injury enhancement charges attached to the elder abuse, which can increase incarceration time. So those are the types of criminal cases that can involve elders, whether it be as a victim, and you also have, people that are accused that are also elders. So it could be on both sides. All right, other types of cases are unlawful detainer, which is the legal fancy way to basically call eviction cases. Elders may seek protection from eviction or removal from their homes when an abuser is a cohabitant or a family member that refuses to leave or is exploiting the elder. That's where they would come into either getting a civil harassment restraining order and also a probate case and also filing an unlawful detainer. So there's different legal remedies that an elder can use to seek protection. The court can issue orders to remove the abuser and restore possession of the home to the elder. And that happens too. You have the cases where there could be an elder who has title to the home and the overgrown son will not leave or something like that, or the family member refuses to leave. and the elder is just at wit's end and they don't know what to do. So they can come to court and seek an unlawful detain or eviction action against the family member. Next. All right, lawsuits against facilities and other civil actions. There may be civil lawsuits, also known as tort actions, filed against care facilities or individuals for personal injury, fraud, conversion, or other harms. And the court may also address issues involving healthcare decisions, financial exploitation, and recovery of assets. And that second part is like, when you talk about recovery of assets, if there is fraud or conversion, there can be a request similar to what I showed on that, on the form. Now that this injury has occurred, what do you want the judge to do to provide the remedy to what the injury was? All right, next. So just in terms of the legal matters, I'll just summarize that abuse can be physical, emotional, financial, and involve neglect or self-neglect. Most cases involve more than one type of abuse, as I've discussed. It can be financial and emotional abuse is very common. The San Francisco Superior Court provides multiple avenues for protection. I mean, all courts do, but for protection and redress, and often works in coordination with APS, law enforcement, and advocacy organizations. There are a variety of self-help resources and free services in San Francisco, and I believe almost all all California courts. I haven't actually personally done the research, but I'm pretty certain that all courts have an access center. And here we have ours on the 5th floor. It's called Access, and they provide help. There's actually staff attorneys, and they're fully well-staffed with volunteers and great students, from undergraduate students, law students, that help the public in filling out the very forms that I showed, that were shown on the screen. And there's the sheriff's department that will help serve the papers for free, as I stated. And there are these agencies that help support elders and advocates through the process. And you also, I think it's important, I don't know if the range of speakers are only in San Francisco, but if you're listening from other counties, I think a lot of counties have various nonprofit public interest agencies that provide services to seniors. Even if it's not something like legal assistance for the elderly or a PILO, there are other public interest agencies that extend services to help the elder population and maybe have grants to do that. There's also, we didn't provide the website address here, but as I stated, Google is your best friend. So there's the San Francisco Superior Court has hyperlink, has pages and tabs specifically for elder abuse. Maybe, am I able to do that? Show? I can't show. Maybe you can show. Actually. I wanted to show it here. Am I able to do it? Oh, good, thank you. So if you go, thank you, Greg. So if you go to Civil Division and you see on the civil, you see these are hyperlinks, and it says restraining order, elder or dependent abuse, and you can click that. And for San Francisco, it really does a great job walking you through how to fill out the form. And then I'd also note that the state of California has a website as well. If you go down, go up. Okay, Greg, click that California Courts Help, Self-Help for the Elder. Do you see that click? More information is available. So this is, in addition to each county having their own website, this is the entire state of California. And so all those forms, as I said earlier, are all on this page as well. And this is a very helpful site. And if you scroll down, it will tell you, it will basically explain everything that I said in much more detail. If you go down, it talks about the overview and what a restraining order can do and things of that nature. And it will hyperlink you to, and it tells you what is a dependent adult. So, and it actually, and you go further down, it has the hyperlink to the forms. If you see that. Go down a little more, Greg. You see that right there? Oop, too far, too far. Right there. So there's the form right there, that this blue hyperlink. All right. Okay. Let's go back to the slides, please. All right. So the courts are invested in making accommodations for ADA individuals as well as elders and dependent adults. Moving on, next page. And we're committed to providing equal and full access for individuals with disabilities and elders and dependent adults. And reasonable accommodations are offered to ensure full participation in court proceedings, such as assisted listening devices, which I talked about earlier. I think every courtroom is fitted with these devices. They're just little headphones. At least in San Francisco, all the courtrooms have a mic now, which does help also. We have interpreters that are free. We have, all the courtrooms are wheelchair compliant and have wheelchair access, and also flexible scheduling. Excuse me, if there's ADA requests, they can be made 5 days in advance, and there's a form also on the website to make that request. It's pretty straightforward. It's one page. And the court will engage in interactive process to identify and provide effective accommodations. I know that's, I mean, I only know how I handle my courtroom, but I think the lawyers and the people here that appear in different courtrooms probably have better anecdotal anecdotes. But I know for me, you know, I'm pretty flexible. I just need to make sure that the record is clear. And, you know, there's times where I have even typed on my computer and made it on the Zoom so that whoever's in the courtroom can read along in large font. So, and then I just make sure I say out loud what I'm typing. So, you know, I think courts should be reasonably accommodating to any needs here. All right, next. As we talked about earlier, there's different self-help resources, the Access Center. All right, next. I think I'm running out of time. I think we talked about this, that elder abuse forms, you know, they don't have a filing fee. I talked about the logistics. Yeah, okay, let's stay here. Let's pass. Let's go to this one. I talked about this one. This is remote and technological innovations. As all of you are here appearing on Zoom, I allow for, and the courts allow for elders and those that have mobility issues to participate on Zoom. Next. The specialized scheduling support. I know if I have a bit availability in my calendar week, I will make accommodations in terms of scheduling. For example, some people have doctor's appointments, even though my calendar starts at 8:30. If they need to come in at 11, I don't have a problem with that. All right, next. So the court also likes to work closely with organizations such as APILO, APS, Community Legal Services, to ensure that elders have advocacy and support throughout the judicial process. And the collaboration helps address not only legal needs, but also the broader health and safety concerns of elder adults. Next. All right, just, so yeah, let's talk about technology. There's electronic filings now. I think that's helped streamline the process so people do not have to actually come down in person. That applies to all types of cases. I think criminal is a little behind, but I think in all civil matters. Next. We have remote hearings and proceedings. While this is not my preference, I do allow for it. And I'll tell you why it's not my preference. It's not because I'm trying to make it difficult on a vulnerable population, but when it comes to the hearing, when you're talking about evidence and documents, the other side needs to be able to see it. And so when you're in person, that's the easiest way to exchange evidence and to view videos. And so that's the reason why it's important to that in person is helpful. And with the overlap and difficulty with audio, I'll note that sometimes, there are some seniors for sure, and people, and it's not just age related, that are much more adept at dealing with technology, and there's some that are not. And so that just kind of comes with, that can be challenging sometimes when you have a lot of Zoom appearances, because some people are not as adept with using the technology. Next. And I'll just note that the Access Center has embraced technology to help people. That is true. They do chatbots and live chat and helplines to assist self-represented litigants who cannot make it down to the Access Center in person. For some of us, whether putting aside whether you have the time to do it in terms of mobility, it may be easier to come back and forth and just run down here. But for some, it takes, it could be a lot longer, and mobility issues could be harder for folks to move around. So Access Center allows people to communicate remotely to assist them filling out their forms. All right. So I'll just end that with the court is always trying to adopt new technology to make things easier and accessible to the public. And we're always looking at improvements. We've already changed our recording system once. We've changed our website already. So there's just a variety of things. I mean, I think there's no shortage of always updating the technology, but I'll just share with everybody here that the court does do its best with the resources that we have and the budget that we have to ensure that we make ongoing improvements. So that concludes my presentation. I'm a little over time, but I think we have some time for questions and answers. Mr. Palmers, I'll let you take over from here, or you lead the way.
Thank you, Judge Tong. Thank you so much for this very informative presentation about judicial process and the advancements in the courtroom. So this time we have an opportunity to ask. If anyone has questions, you can put it on the chat, or you can raise your hands and we'll unmute you.